Wayne Steedman. I'm a private attorney I'm an attorney in private practice, doing primarily special education law. I also head a group called the Maryland Special Education Lawyers, all of whom are lawyers who are working on special education in private practice and public interest. There are a number of things that you heard from the previous panel that I wanted to respond to. One, they talked about if this bill passes, it'll give parents unilateral decision-making. Well, that's inaccurate. It only applies to 5 areas of the IEP process. The school system still has control over a large measure of the IEP process. Basically, I think what the school system would prefer is that they continue to have unilateral decision-making. Actually, that was what the representative from Washington County said when he talked about making unilateral decisions. Someone talked about that this bill would usurp the team process. If you look at the statute, both in the federal law as well as in Maryland law, it's the first person listed on that team. It has a list of who the team members are, the required team members. First listed is the parent, yet that person is forgotten. The parent is forgotten all the time. So when they talk about a team, they're only talking about themselves, the school. And parents will often get reports from the school saying it was the team decision that, well, that wasn't the parent's decision. It was the school team, so they should clarify that. But when they talk about usurping the team process, basically what they're saying is that parents now are going to be more equitable or more of an equity partner in the decision-making process. And I think it's important to note that the IDEA was passed as a law in equity, which means that it has a provision of fairness in it, that it's supposed to be equitable and equitable principles. There's a provision in the statute that even says that if parents are denied significant participation in the decision-making, that constitutes a denial of FAPE. But what happens so often in these IEP meetings, as you've heard from a number of people, is that parents are not participants at all. They sit in the meeting, they're allowed to speak, of course, but they're not heard. They're not listened to, and nothing that they offer is really considered. So that creates, a significant problem that does undermine the principles of the IDEA. There was some testimony that the Commission on Equity, the 2013 Commission on Equity in Special Education, already considered the consent bill. Well, that's a little off. It's a little inaccurate. That commission considered a consent bill that would be for the entire IEP. We've narrowed it. Because we realized that the commission felt like that was too broad. So this bill, Senate Bill 950 before you, narrows it. And we wanted to keep it more specific than be so broad as to encompass the entire IEP. This should be a partnership. It needs to be collaborative. We want it to be that way. I honestly, even as an attorney who represents parents, I don't think parents should have complete control and make all the decisions. I don't agree with that. Neither side should. And that's what we're asking for, equity, what the law considers. I'm going to give you one example of a case I had a few years ago where a parent sat in an IEP meeting in which the team decided they were going to move his child to a school where the child had been previously bullied and harassed and actually assaulted by other children. The father begged. He begged that team not to do it, and they just went ahead and said, no, we're going to do that. We know better than you, after all. The parent became so frustrated that he stood up and threatened the lives of every member of that IEP team. Obviously, that was not a good thing to do. They had him arrested. He was charged. And then he was given an injunction that he could not attend be on the property of any school in that school district for a year. He had 3 other children in public school, and he could not go to their basketball games, their after-school activities. He couldn't meet with the teachers. He could not attend the school anymore after that. That child ended up going to a private school because the parents were so upset about the possibility of him being bullied and harassed and beaten. They went ahead and went into debt, took a second mortgage on their house, and put him in a private school. I represented them in a due process hearing, and we won. Now, there's a fiscal note in this bill, or not in the bill, but there's a fiscal note attached to this bill, and I want to just point something out. That parent would have been happy if they had placed that child in another public school, but they refused to do that. So they went and put him in an expensive private school. It cost over $40,000 a year. We won that due process hearing, and the school system was required to pay for that. Plus, there's a fee shifting provision in the law that says that when parents win, they get entitled to reimbursement of their attorney's fees. My attorney's fees bill was $50,000. It cost the school system $90,000, and it wouldn't have cost them a dime. And that's just on our side, because they hired a private attorney who they paid more than I got paid. And they also paid 11 witnesses to come and testify during that hearing, and I have no idea what